Hello everyone. We are here today to discuss certain important concepts of contracts. The Indian Contract Act of 1872 governs contracts entered between parties. So I'll be starting with certain concepts of contract law through various examples. So for example, how do you buy a book? We go to a shop, we see different books on those bookshelves, and with different price tags, and I choose, for example, 3 different books that I want to buy. So I take those books, I go to the shopkeeper and say that I'm willing to buy those books on the price tags given on the books, and to which the shopkeeper may say that, hey, listen, these books have old price tags on it, and I would like to negotiate the price. So what is it? Did you make an offer? Or was it an invitation to offer by the shopkeeper? So I'll tell you concepts like invitation to offer and the difference between them. So the books that you see on the shelves, or the catalog that you read, or the advertisements online, all of these are invitation to offers. What do you mean by invitation to offer? So for example, when the shopkeeper has put certain books on the shelves with old price tags, the shopkeeper's intent is to invite the general public to make an offer. And then the shopkeeper is willing to negotiate on it and then accept it, after which a valid contract will be formed. So when you are looking at those books and saying that I want to buy these books, that is basically an offer that you are making. That offer is made only when there are 2 things. First, willingness. Willingness means the intent to enter into a legal relationship with the other party, with the shopkeeper in the instant case. So when you say that the legal intent is missing. So there was a very famous case of Balfour versus Balfour, where there was a husband and a wife. They were living together in England, and when the husband had to go to the workplace, the wife was supposed to be in England due to her health reasons. When the wife was there in England, the husband used to give her certain money for her maintenance. After a period of time, the husband stopped giving her maintenance, and the wife sued him for money and the maintenance. So, do you think there was a legal intent between them when the husband was giving her maintenance? No. The court held that in familial relationships, or in relationships out of love, in certain instances, for example there was a legal intent which was missing in the case, and hence the valid offer, and hence there was no valid offer and there was no valid acceptance. So there was no contract formed. So now we move on to the second ingredient, basically the willingness to obtain assent of the other person. That is when the communication done is complete. So how do you know that the communication done is complete? In the instant case, the bookstore case, when you take these books to the shopkeeper, communicate your offer, the valid offer, in absolute terms, and say that you want to buy those books at a particular price with complete ingredients. Only then, and that comes to the knowledge of the other party, only then a valid communication is said to be made. So for example, in the famous case of Lalman Shukla versus Gauri Dutt, what happened was Gauri Dutt's nephew was missing. So what Gauri wanted to do was to issue some kind of reward for anyone who finds the nephew. So the servant of Gauri Dutt went and started looking for the nephew. He only after finding out where the nephew was, it came to his notice that there was a reward. So when the offer was made, it did not come to the knowledge of the servant. So the court held that the servant cannot later go on to the court and say that Gauri Dutt is bound to give him the reward, because he in the first place had no communication, had no communication of the offer that was made by Gauri.
Hi everyone. Continuing from where Shreya left off, the next concept we need to discuss is that of acceptance, because once we have the offer, once the offer has been communicated to us, the next step is to decide whether to accept it or not. So, the very definition of acceptance under the Act is that it has to be an unqualified and it has to be an unconditional acceptance, because as soon as you give your acceptance but you put an underlying condition that you will agree to this only if this particular condition is fulfilled, you are not actually saying yes, you are making a new offer by itself. So the whole process of negotiating and making an offer and making an acceptance will start from scratch. So in our bookshop example, once we agree to the price of, let's say, 300, and later you say that no, I've changed my mind, I'll buy it only for rupees 250, you are making a counter offer, and this is not a valid acceptance because this is a conditional acceptance. So the whole process will start all over again. Now once you have decided to give your acceptance, and once you have decided that it will be fully unqualified and it will be absolute, you need to know that you are giving your free and full consent, and consent is actually the second most important essential of a contract, because even though you have the offer and the acceptance, was the acceptance fully qualified and valid in the first place? And this is where the concept of consent will come in, because once you agree to enter into a contract, it is a two-way street. You cannot say that I gave my consent under threat or I was under fear of being beaten up, because that is not consent, that is not an agreement in the first place, it's a disagreement. That is why consent and acceptance go hand in hand, and both of them have to be absolute, free and voluntary. And this is where the phrase consensus ad idem has to be kept in mind, because you cannot agree to something which you never understood in the first place. So in this case, the bookshop, the shopkeeper and the customer, you need to understand that consensus ad idem will mean that they've agreed upon the same price for the same exact book. Otherwise, the shopkeeper will think that he's talking about some other magazine, and the customer will think that, oh, he's buying the Lord of the Rings trilogy. So you need to accept on the same particular thing, on the same subject matter, and the understanding between the two parties has to be same. So once you have your offer, communication of the offer, once you have your acceptance, and once you have understood the subject matter and the details of the offer and your own acceptance, you will have a full binding contract when you also are of majority age and of sound mind. This takes us to the fourth essential of capacity to contract, because under the Contract Act, only a person of majority and only a person of sound mind can actually form a contract in the first place. So you have your offer, acceptance, capacity, and the fourth essential becomes consideration. So although you have agreed to something, what was the actual reason for your agreement? This reason for agreeing is actually called consideration, because consideration is something that the other party will do for you because of your wish, and the consideration for the other party will be something that you have promised to do for him. So consideration is actually the underlying value of a contract. For example, in the case of our bookshop, the consideration for me is my book, and the consideration for the shopkeeper is the money. But consideration need not always be monetary. Consideration can be any act that you have promised to do for the other party, or in some cases, in cases of gift, consideration can even be love and affection. So you have your consideration, you have your capacity, and then you have made your offer and you have given your full acceptance. This actually takes you through the 4 stages of contract, and this actually turns an agreement into a contract. So this is a very small but often overlooked distinction. Not all agreements will amount to contracts. So what happens is that even though two parties may have agreed to something, it might not be enforceable by law. So any agreement which is not enforceable by law can never be a contract. So what you need to understand is that the whole point of lawful object will come into play here. You cannot agree to murder someone because that is an unlawful contract. It's an unlawful agreement. That is why it can never amount to a contract in the first place. So you cannot agree to do something impossible also, because impossible by definition is impossible. So again, it's not enforceable by law, and that is why again the agreement will fail and it will not amount to a contract. So just to summarize the whole process, this session was to learn about offer, communication, acceptance of that offer, giving free and full consent, having the capacity to enter into the contract, and actually turning that agreement into a contract because you have lawful consideration and you have a lawful object, and the contract is not impossible to perform. So when you have all these four main essentials covered by the umbrella of legality and being of capacity, automatically your agreement becomes a contract. So that was it for this session, and hope you learned something.